All right, everybody, welcome to the Creative Finance Collective. I'm Andy Fowler, and I'm here with attorneys Alan Seshker and Sean St. Clair, and it looks like we might have Scott Horne. Let me check. Scott, can you hear us over there?
I got you. Can you see me over there?
Yeah, I can. I can hear you. I can't see you,
Uh-oh.
but we can hear you.
There is always something in there.
Yeah, there's always something brewing over there in Texas. Always.
It's Alan's fault.
Yeah. Well. If you're just now joining us, this is the Creative Finance Collective. So we're talking about all things creative finance. If you have a question, that's what we're here for. I mean, we're here to talk about legal issues that we see in the creative finance space, but we're really here to engage with the viewers and the listeners to answer questions or give directions as best we can about all things creative financing. We've represent a few different states here, Arizona, Texas, Wisconsin, mainly right now. So if you're watching, go ahead and post those questions in the chat and we'll get to them. We were talking offline just a little bit ago, and Alan, you were mentioning you've seen some more due on sale clause problems. Is that right?
Yeah, we've had two more since my last attendance, which I think was a couple weeks ago. And they're from the same company, Home Loan Serve, which I hope I can call out companies like that. I think it's still caused by the incorrect insurance getting in place.
Okay. Break that down for us, what you mean by that.
So the way we structure it or advise people to structure is seller cancels their insurance, buyer gets new insurance, and then the buyer is named as the insured. And what we've been doing is the seller, in order to be on the deck page and have the mortgage company check that box, is an additional interest. And then, of course, put the lender down there on that mortgagee clause. And that's been working pretty darn well for 15, 20 years. But now, like I said, it's been an increase. It's not a high number, still a very low percentage, but instead of 5 over 1,000 files, we're having 5 over a couple 300 files. So still, again, small percentage, but a problem.
So for the listeners' sake, treat me like I'm a kindergartner, Alan. If what is it about getting the insurance wrong that tips things off to the lender? How do they even know that happened?
So the loan servicing company handling everything for the lender has to check off boxes, and one of the boxes they have to check off is that there is insurance, and then as part of that box, they have to check off that the insured is their borrower, and so now everything's good, and that box is checked as well as a bunch of other boxes. They paid the right amount, and what have you, because that can be done incorrectly. That's, in my opinion, that's what's causing the due on sale clause issue, is insurance getting put in place incorrectly.
All right.
Let me chime in just a minute, if you don't mind, Andy.
Sure.
So in light of what Alan was saying, I've had, just like him, 2 due on sales in the last couple of weeks, as you don't see. One was actually out of North Carolina, and it was this poor gal's very first deal. I'm still sure what exactly happened. It just happened. And no one up there knows how to fix the problem, it seems like. So we're going to help her through some things we can do here through our national doc drafting firm, get some things done to help her do some restructuring that hopefully will help to solve the problem. And of course, one of the things I know that I always try to do when you're doing due on sale is you tell the client that there is no magic pill that can make it go away. There's some structuring things you might be able to do here and there, but there is never a guarantee of anything. And in light of what you and Alan talk about insurance, I think insurance is one of the biggest things that can come up that, of course, creates due on sale issues. And as Alan said, so many people miss the fact that if you're doing a house subject to the existing debt or doing a wraparound mortgage, that original seller, the guy, whoever's the borrower on that underlying note, better be the named insured on the policy or named as an additional insured, or the lender's going to kick it out. And I find this interesting. I was in a conversation just 3 or 4 days ago with an insurance company. We're going to do some videos here with them because they were pretty decent for all of this. And one of their comments was, and I see this so often in this creative finance sphere. I'm sure Alan does too. I don't know about you guys in Arizona. And, nobody does anything in Wisconsin, I guess, do they?
They just mow grass.
Yeah, they just mow grass. Or eat cheese or something like that. Or is that they cut the cheese? I'm not sure which one that is. Sorry, Sean. But, they were saying that when you buy a home subject to the existing debt, there's a lot of people that want to leave the existing insurance in place, which means the original borrower is still the named insured on that policy. And what I found interesting was they told me point blank that if you do not adjust the insured on that policy, the policy could be nullified by the lender in the event of a loss. And I was going, what do you mean? Explain. They said, you have to go through and read this whole damn policy. Down at the end, it says that's X, Y, and Z, which I couldn't recite to y'all right now. But it was understandable that when you sell the home, the person who bought the house, the investor, the end buyer, whomever, they should be the named insured on that policy, not the original seller. Now, that original seller would be named as an additional insured. And their point really resonated with me in the point that if you don't do that, and in the event of a loss, they didn't say it was 100% chance that they wouldn't insure it. They just said that there's a possibility that they won't insure it. And when you hear that, you kind of go, yikes, let's make sure you do that the right way because things happen. And literally just yesterday, I get a phone call and I got a wonderful DTPA letter from some lawyer out of Beaumont where they closed, and this is a thing that says things can happen. And they closed, or a transaction was closed by an investor. I believe it was a wraparound mortgage. And all we did from my offices is we were a loan processor on this transaction. Some title company down in Beaumont closed this transaction. And for some reason, the insurance didn't get paid. I don't know if they didn't have an invoice, what the problem was, what happened. And guess what happened in that 10-day lag time? House burnt down. Things happen in our industry, unfortunately, especially in the investor world, sometimes with lower end houses or whatnot, or because of construction issues. And it is so important to understand how insurance flows, to get a good feel of that, do it the right way. It's okay if you guys spend a few extra bucks because otherwise you may eat the entire loan balance possibly, which you don't want to do. And then the structuring of these, just to understand that, I think is so important. And when you mess that up, that to me, I think, I know you guys will agree, it's the number one way that mortgage companies know there's been a transfer of the property or a problem arises because of that, and all the red flags go up.
So kind of a question to all of you. We've talked about this a lot, but creative finance is fraught with risk, tons of legal issues around it. And we say over and over again, hey, not every lawyer is created the same in any area of the law. Everybody's got their niche. Find a good lawyer who's going to help you with doing the documents correctly. Not all title companies are created equal. Find a title company that knows how to do this, knows how to close the transaction appropriately, and knows how to deal with the sophistication that's required in a subto creative finance transaction. The same is really true for insurance, isn't it? I mean, not all insurance agents are created equal. That doesn't mean that some are good and some are bad, but some have a focus and some don't. Alan and Scott and Sean, I mean, in your practice, is who you choose as the insurance agent as important as the lawyer and the title company?
These days it's almost more important, and we're actually making a move from our one of our go-tos, and we only had two. And if they didn't use one of those two, we added a document that said they release and indemnify us against all damages related to that. But one of them won't. One of them's not able to list the sellers as an additional insured, just because of the underwriters that he works with, and so we've actually had to switch out and go with another. And we're constantly interviewing insurance agents to find the right ones, just like you said. So almost more important these days.
Oh yeah. I can't mean the right lawyer is number one. So I think in Texas there might be 3 or 4 people who do this the right way and have a good working knowledge and think through the deal and actually understand it. I've got another deal right now, just in that same light, guys, where a title company down in Houston closed the transaction. The lady bought it, or they sold it subject to a buyer. This title company, I don't know who drafted the documents. I don't know anything at this point in time, other than all there is a general warranty deed. There's no deed of trust. There's no vendor's lien. There's zip. And guess what the status of payments are? They're 3 months behind right now. And no one's communicating. And of course, in that scenario, I've got to turn them over to litigation counsel and instigate the lawsuit as opposed to a simple foreclosure. And maybe that lawsuit will help to incite a deed in lieu. But equally as important as knowing the right law firm to close these deals. And what I see in the investment world, and you can tell me if I'm right or wrong here, is so many people think because they go to a title company and it closes in a title company, doesn't matter what the flavor of the month is of that title company, that everything's just fine. But these title companies could care less about the disclosures that are so important. You know, here in Texas, we have all these things we got to think about. In Arizona and Wisconsin, not so much. But they don't look at this stuff. They don't care about it. They just want to close the deal, issue title, make their money, and move on. They don't represent anybody. They don't care whether it's compliant, not compliant, or whatever it might be. And just like with insurance, as Alan's saying, it's equally as important to interview these insurance people. Ask them all the questions. Ask them the right questions. And if they can't do it, go find the next guy who can do it and actually understands it. So you don't know. I always think about Pancho's Mexican food, if you know what I'm talking about, Alan. It's only here in Texas, probably.
Yeah.
We ain't going to take y'all there if you come to Texas, okay? But you'd raise your little flag when you wanted more food, and they bring it to you. But that's what I envision. Every time you do something wrong, especially with insurance, you're raising that flag, one notch higher for something to come up.
Well, one point I think is well taken that you mentioned, Scott, is title companies, insurance agents, lawyers to this, you're not required to use any one particular outfit. And I've seen situations, title companies specifically come to mind in this case, not involving creative finance, but where we were dealing with some unique lien issue. And for whatever reason, the title company couldn't wrap their mind around it. It wasn't even that complex. They just decided this was too much of a problem. But guess what they did when we said, you know what, we'll just take our business elsewhere. Suddenly they were okay doing the job, right? So you don't have to use the first person that you go to or referred to. There's no requirement there. But I'm wondering and I've seen this with title companies, but Alan with insurance and Scott with insurance, are you seeing fewer and fewer agents that have underwriters that'll underwrite this? I mean, is this becoming more difficult to find over time to have folks that can actually insure these deals?
Well, like I said, I had two go-to people, and so we weren't really looking for anyone else. And if you go ask a title office, ask an attorney, ask an insurance company, do you know how to do X? And that's in relation to creative finance stuff. Do you know how to insure a mortgage wrap transaction? Their answer is yes. And then they're going to try to figure it out. And they're going to call me and ask me, and I'm not going to teach them. I'm not taking on their liability. So I don't think there's less that can do it. I just think it's, really it's incumbent upon us to direct people to the insurance agents that we know that can do it. And whenever they say, well, no, my Aunt Betty's been doing my insurance forever, and I want to get this what do they call it? A bundle package. You tell them, no, on this, you're not going to, because it's going to cause your transaction to fail and you're going to lose the property. So I think we have to start being stronger on it.
Yeah. That's an interesting point. Yeah. I could see where a lot of folks would try to package the insurance, where you were going with their insurance on everything else. So they get the package deal where they bundle it all together. And then it turns out that agent that could do all the normal stuff didn't do it right when it came to the subject too.
No. And Alan, in that same light, we get that occasional call here and there. And for the right guy who asks the right way, I'll give him some info along the way, things that they need to be thinking about and or considering. But I don't like to train my competition if I don't have to. I don't want to do that. And I will drop this on you guys. I find this a little interesting. I just got a file sent to me to review for a closing. And I looked at it, and the file is my file. All my same documents, everything verbatim with their copyright on my copyrighted documents. And I'm just going, you got to be kidding me. So that phone call is fixing to happen here when this call ends.
Oh man, we got you. You're not going to let us live stream that one?
Oh, I would love to live stream that one. We're fixing a lot of.
Call them up.
Yeah.
That would be great TV, man.
I get, people, we all, take a little here and a little there. I get that. Okay. That's just, all of us lawyers have done that at one point in time, but we also make it our own in some format and take care of things. But, oh my goodness gracious, is all I can say.
Well, I'm going to have to tell you something. So the exact same thing happened to me, but I embed typos in my documents. And so when they copy them, they copy the typos. And so the investor client that brought that to me, he was the one that gave my documents over to the other attorney to do them cheaper than I do, and then brought them back to me for the closing. And I said, you understand this is the worst case of pirating I've ever seen in my life, and I'm not going to close this, don't you? He said, yeah, I understand, and went on.
Yeah. Isn't that funny though, how they do that? And of course, what I find interesting, guys, is in our industry, and as we said earlier, there's a handful of us who become, for lack of a better word, students of the industry. Because anybody, they'll say, just like Alan said, sure, we can do the deal. Then they go try to figure it out along the way, whatever that might be. And sometimes they call their client and ask for help, do this, do that. And they try to piecemeal it together as they're going forward. But at the end of the day, you get inside of the creative finance world. I think trained monkeys can draft the legal documents necessary for this deal within a certain degree. And it boils down, in my world at least, to the disclosures and having the ability to help the client understand what they're doing, whether it's buying, selling, everything in between, like with insurance and these kind of things, and to give them proper information so they don't go out and stub their toes. And that's where I think so many people who try to close these deals, they don't care about that. All they want to do is just close the deal and move on to the next deal. And for us who are in it, we want to propagate it, do it right, help our people succeed, be successful, and hopefully not screw up.
Yeah.
Well, in all fairness, I don't think it's always just a matter of lack of caring. I think they truly don't know the full aspects of the transaction. They don't understand. So whenever some kind of zig comes up, they don't know they're supposed to zag. They just don't even know that they don't know.
Yep, I agree.
All right. If you're just not joining us, we've been talking about some recent cases of the due on sale clause being triggered. I think probably because insurance being done poorly. It's an easy topic, insurance, to try to ignore it because it just sounds so boring. But as we've kind of just discussed in the last 23 minutes or so, it's maybe among the most important considerations that you think through, that you hire the right professionals for on a subject to transaction. You don't want to get that wrong. If you are just joining us, we're taking questions on creative finance, so make sure to post those questions in the chat and we'll get to those. So we have a question probably tagging along with us talking about the due on sale clause being triggered. But it says, after insurance, what is the most common reason a lender might trigger the due on sale clause? Or maybe a better way to say that is, what's the most common reason you think or you're seeing might be second to insurance that is a big red flag or something to stay away from?
Well, besides the obvious non-payment, slow pay issues, I think the only other one I've seen that's probably the most common is not navigating probate situations properly, either before or after the equation comes up. For some reason, people think that because someone passes away, you got to call the mortgage company, and tell them, and you don't have to do that. Just keep making your payments.
I think for me, the most common after insurance is what I'll call either lack of education of the parties or a seller actually getting angry and trying to blow up the transaction themselves, and they actually call the lender. But I've had people, investor brings the contract over, and then we get an email, hey, I called my mortgage company and they said that we're not doing this right. And so I think the education factor. Yeah.
I'm sorry, I gotta laugh at that. I'm sorry. God.
Yeah. Well, so much of, that just begs the question, how, you should be doing proper disclosures anyway, but my guess is usually angry sellers are angry because they felt either lied to or misled. Whether any of that's true or not, that's the way that they felt. So they're going to take it out on you. But a lot of that probably can get cured with just good disclosure. Can you think of circumstances, Alan, where you've seen people just outright getting angry and calling it due, that better disclosure would have made a difference, or you think it wouldn't even have mattered?
I think it's key.
Yeah.
The education disclosure and written disclosure, not just say, hey, this is a subto transaction and then move on. You explain what it is and have them sign off on it in some form or fashion. I'm not saying a signature, but at least a reply to an email where we can show, hey, you understood this.
And I don't, yes, Alan, you're 100% right. But I think when you get a disgruntled seller who's disgruntled either because the person who bought the home is slow pay, no pay, whatever it might be, and you start to get some credit effect. Had one situation where the investor had bought the property 2 years hence, been paying on time, etc. The seller somehow finds out he's doing a wraparound loan to somebody for a lot more money. And all of a sudden, even though the investor stopped the foreclosure, brought the loan current, has been making payments, doing all the right things, the seller now thinks he's been disadvantaged because the investor is making some money selling the house for more down the stream. And This guy comes back and goes, oh, well, you owe me X. And if not, I'm calling the lender. And here we go. And of course, they're willing to cut off their nose to spite their face sometimes.
Yep. Don't make the seller mad.
Yeah.
If you're just out joining us, everybody, we're talking about creative financing and taking any questions that that y'all have. So if you have a question, but make sure to post it in the chat. We'd be happy to get to it. Scott, I know you joined a little bit later, or just as we were starting the episode, just so we didn't have any time to talk before you were on. Any new issues you're running into out on your neck of the woods that you've seen or worthy discussion points?
Oh gosh, you're gonna make me think now, and it's late in the day, but
Well, I was just really hoping you'd get upset and make that call and give us an audience to it.
oh, if I had permission from my litigation counsel to do that right now, I would do that all day long.
Yeah.
And as soon as a certain business partner of mine who already knows about it hears of it, it's fixing to light up the internet somewhere, I think. Hell hath no fury, I think is how that one goes a little bit. But, other than it's just you keep seeing the same issues arise, and you want to help people walk through this. I'll go back to this example in North Carolina where I know the name of the attorney who handled this one closing. It wasn't anything that they did wrong, why the due on sale got called. In fact, I don't even know why it got called per se. But their solution was not a solution. Their solution to the problem was, well, you can either sell the property or refinance it. That was their sole solution to the due on sale clause. And I just look at that and go, yeah, no. If you're going to be in this biz and claim this stuff, take the time, figure out how to do some, for lack of a better word, fancy footwork, maybe that can help to get around the issues in some format. And again, there's never a definitive way of doing it. I've been very lucky in how I do some things to be successful each time, but it just doesn't mean that the next time you ever will be. And, it's just, but it's giving back more than just basic common sense answers is what I wish the industry would learn. And I don't think the industry will ever learn that, unfortunately. I think it'll be a constant ongoing scenario. And again, here in Texas, the title insurance industry has an extremely strong lobby in Texas. Besides I think the Home Builders Association, the Association of Realtors, I think the next is the title industry for your big three out there. And they always want to get themselves inserted into a transaction. I always ask questions here in Texas, and I hope Alan will agree with this, but they say in our property code, all these issues, that you have to close these transactions in a law firm or a title company, or they can be void, not voidable, but void. And I'm going, why in a title company where the escrow officers and typically most 99.4% of the title attorneys, they don't get this deal and they don't look at the disclosure basis. And unfortunately, our legislature seems to miss those points sometimes on the finer things. I'd have to think for a minute about other things that have hit in this last week to comment any further from what I already have.
One of the things I'd like to explore in the future, and I don't expect you guys to have an answer to this, but just a discussion point. Sean and I, on our podcast earlier today, interviewed an attorney in Virginia that does a lot of investor transactions, and we talked a good bit about wrap transactions and agreement for sales or land installment contracts. And one of the things that I came away with, which I thought was really interesting in Virginia, and Sean, correct me if I have this wrong, but my understanding from what she said is, I know you guys have issues with agreements for sale or contracts for deeds there. We can do them here in Arizona, but we've got a body of law that dictates how that interest is forfeited over if payment isn't made. But in Virginia, there was seemed to be pretty wide latitude, or the Virginia law left a lot to the contracting parties on how that interest was going to be forfeited if the buyer didn't pay, which I thought was pretty interesting, which made it really a desirable transaction. Sean, I know you're not a Virginia lawyer, but do you think I summarized that accurately?
Yeah, it seemed like a lot of the remedies were dictated by contract. And what I thought was most interesting, though, was the whole idea that you could do an assumption deed, whereby in the actual deed it says that you're assuming the seller's obligations under whatever loans you put in there, and then they combine the assumption deed with a pocket deed back to the seller, and then the terms of the assumption deed dictate the notice requirements to then record that pocket deed if the buyer defaults. I thought that was it. So they don't even do they can, but they don't always do a promissory note with a deed of trust wrap. They do an assumption deed, and the terms of the assumption are set forth in the deed itself with contractual remedies and a pocket deed back to the seller, which, I know a lot of investors want to do the pre-signed deed in lieu and whatever, but in Virginia, apparently you can kind of do that. Well, you can, you can do that through an assumption deed. I don't know I know in Arizona and Wisconsin, we have nothing like that. I don't know if you guys have that in Texas.
No.
The belief here in Texas is that that advance signed deed in lieu is executory and not enforceable.
Yeah.
Yeah.
No, it was it was interesting stuff. We've invited her to the collective, hoping to have her in the future. But yeah, it was really interesting to see another state's take on some of that.
I will say, Andy, just real quick, back to a contract for deed. So in Texas, you can actually draft a contract for deed, agreement for sale in y'all's area to a homeowner if you have no debt on the property. You just have to meet certain requirements along the way that are pretty onerous out there. And then, of course, this buyer can convert to a mortgage at any time they want to convert to. It's almost like you're wasting time in that regard. Now, flip side, go to a commercial transaction, non-owner occupied. Now, in that world, as you said, pretty much anything goes. It's up to the contracting parties to decide what they want to do. In the event of a non-payment, is it an immediate termination, 5-day notice, 30-day notice, something more, something less? Commercially, you have a lot more latitude than you do when you're dealing with that consumer on an owner-occupied property.
Yeah. All right. Well, guys, we've been going for about 40 minutes or so, and we don't have any more questions. So I don't want to burden your time any further. I know you've been kind enough to come here. What we'll go ahead and do is wrap it up, and we'll plan on hitting it again next week. If you're watching, make sure to bring your questions. The longer we get questions, the longer we stay on. So looking forward to getting those. Make sure to be with us every Tuesday, Arizona time at 2 p.m. So adjust your calendars accordingly. With that, guys, I'll let you go. Appreciate you taking the time.
See you soon,
Yeah,
guys.
thank y'all.
All right.
Appreciate it.
All right. Have a
Great
good
day,
night.
y'all.